Hello, Psych and Law. How are we today? Not good, huh? Annika's here to help us out. I don't know if she's going to stick around, though. She just took a nice long nap. She might have busy things on her kitty agenda. Hard to know. Maybe she'll just crash out. Maybe she'll torture us. I don't know what her deal is. So, we are still with jury trials, but we're going to focus on the decision-making, things that happen within the jury box rather than the selection process as we did in Lecture 12. And as promised, homework number 9, the second part of it is embedded in this lecture. So let us get started. Well, where are we going to go with this? Well, we're going to talk about jury nullification first, and then we'll move on to this question: are juries competent, and what on earth does that mean? And we're going to look at the impact of opening statements, how people determine liability in civil cases, assessing damages, instructions to the jury and how they're processed. Really, what's going to happen, I think, that's critical to this idea, and the more that I work in the realm of social psychology, the more I'm understanding the importance of narrative, and that's really kind of the story of the story model, if you will. And then concern for the social order, I'll talk about some research we did that kind of pulls all this together. So jury nullification. Well, what is it? Well, it's when a jury acquits a defendant who's legally guilty because they disagree with the law or its application. So, for example, when I was a teenager and cannabis was illegal in California, it was a felony, right? So the simple possession of a single joint, right, a single cannabis cigarette, could lead to a felony conviction and minimum 2 years in prison. And, you know, a lot of people in the 70s were smoking pot. There's no two ways about it. And it's like, hey, it's cool if you're a rock musician or a movie star. Yeah, you go for it. But if you're just some kid out on the street, watch out because you might get swept up and have to pay. Well, the juries were getting more and more reticent about convicting someone when they understood that the penalty would be a felony, 2 years in prison for a joint. So although it was clear that it was demonstrated that the defendant had, let's say, the cannabis in their possession, right? Not really a question. The jury would still sometimes acquit, that is, find the defendant not guilty, because they just felt that the law was out of line, that it was disproportionate. So this is what jury nullification is. The defendant legally guilty, but we disagree with the law or its application, so we simply won't vote to convict. Now the jury has this power, but some people, you know, and this is controversial. Certainly the jury has the power because they do it, and they can do it. But it's not a right, at least, you know, our textbook says it's not a right, but I don't even know what that means. So the jury has the power. It's probably not a right means that it's not written that this is something that the jury may do. But big question that comes out of this is, should judges tell jurors about this power? Should the jury instructions include, hey, you have the right to nullify if you don't agree with the law in spite of the evidence pointing to guilty? Well, judges are not big on doing this. It's unlikely they will. But what does it matter? So now we get to the empirical analysis. We get to kind of the decision making. And Horowitz in 1988 did a study. 2 variables were manipulated in the study. So the first independent variable was the type of offense. Right? And the second, and they used 3 offenses, which is typical for research in this area. And note that I gave you 3 offenses in the first part of homework 9 assignment, because it's just kind of the way we think about this, people who do research in this area. And then the second independent variable was instructions from the judge. Nullification instructions were given, or the control condition is nothing, which would be typical. The verdict then is on a scale of 1 to 6, very confident not guilty, right? And 6 being very confident guilty. So 1 not guilty, 6 confident guilty. What do we see? Well, the first case is a drunk driving case. And what we see, remember, 6 leans more towards guilt and one is less towards guilt. So if we look at the drunk driving case and we see the nullification instruction, we see that when jurors were given the nullification instruction, they actually came down slightly harder on the defendant. The verdict score was slightly higher than the control condition, the none. Now, if we look at a case of euthanasia, that is mercy killing, right, we see the opposite occur. And then finally, in the third case, illegal possession, we see, in fact, the nullification instruction even further demonstrates the endorsement of not guilty in this regard. Right, Annika? So, as we do research in this area, and many of us have found that at first we think, oh, this makes sense, this is the way it's going to go. This is the results we expect to see in our experiment, but we're often surprised. And that's why at least two variables are typically manipulated, because life is complex. Life has a lot more than two variables, right? But it's laboratory research. We have to exert some level of control. But it's a more nuanced appreciation of how these variables interact that give us the true story of what jurors are likely to do. So jury nullification, there's racial undertones in this country, right? What we see then is, let us say that we have a white defendant, or in the South, we have a white jury. The white defendant is clearly guilty of a crime, a lynching or whatever else, but the jury won't convict, right? This is a type of jury nullification. So a lot of racial undertones, and this is where we're fraught with some of the issues and the controversy surrounding it. Now, the flip side of this, which is very rarely discussed, is jury vilification. And this is when the jury ignores the law and convicts someone even though they should legally be acquitted. Now, it's not such a hot topic, right? The deal is that if we find a wrongful conviction, there are appeal options available to us. At least if we have the money and we have the ability to exercise and find a lawyer to pull this off. So scholars agree, though, juries should not have the power to engage in jury vilification. So it's not an even two sides of a coin issue. The consensus: nullification should occur when community has objections to a law, but not the government or the police, right? So more fine-grained, more specific, more detailed. This law is not right. This is unfair. So the application of the law to this defendant, we're going to nullify. We're going to ignore the law in this regard. Using it as a device to combat the police or the government, probably not the best idea. At least most scholars will agree on this. Now, let's get back to this issue, because there's a recent court case. Let's get back to this issue. Should jurors be told that they have the power, not the right, but the power, if you will, to nullify? Well, Eric Patrick Brandt and Mark Ian Acelli were handing out pamphlets outside a Denver courthouse in 2015. These guys and others believe that, in fact, the jury should be informed of their power to nullify. So they're out in front of the courthouse. They wanted to inform the public about jury nullification. That is the power of jurors to vote against convicting criminal defendants under laws that jurors believe are unjust. So here we are. We're going to stand outside a courthouse in Colorado, and as people walk by, we're going to say, hey, are you on the jury? Are you interested in information about jury nullification? And if someone says yeah, then we hand them a pamphlet. That's it. And we say, this is jury nullification, and explains it. The pamphlet, some of the contents: jury nullification is your right to refuse to enforce bad laws and bad prosecutions. Once you know your rights and powers, and notice these people are saying rights, we'll agree on powers at least, right? You can veto bad laws and hang the jury. So when it's your turn to serve, be aware. You may and should vote your conscience. You cannot be forced to obey a juror's oath, whatever the hell that means, and you have the right to hang the jury with your vote if you cannot agree with other jurors. Well, so imagine, we got these guys outside the courthouse handing out these pamphlets. Well, that's not going to fly with some people. Some people are going to say, no, this is an egregious attempt to influence jurors. This is akin to jury tampering, right? The two activists' attempts to educate the public led to their arrest. Brandt and Nina Acelli were charged with 7 counts of criminal jury tampering under Colorado law that bars any person from communicating with a juror with the intent to influence the juror's vote in the case. But were they? Or were they simply educating about jury nullification, exercising essentially First Amendment rights because it's speech against the government, so to speak, or for the government, as you will. 4 years later, and this is going to go through all kinds of courts, all the way up to the Colorado Supreme Court. In contrast, Lane concedes the U.S. Supreme Court has never recognized that jury nullification is a legitimate exercise of the power of the people. But they clearly do have that power, and Eric Brandt and Mark Iannicelli were simply informing prospective juries that they do. Now their efforts have been deemed legal by the state's highest tribunal, that is the Colorado Supreme Court. So there it goes. Fascinating case, right? And wow. What would it get for you to spend your spare time standing out in front of a court handing out jury nullification pamphlets? These folks are dedicated, right? They're on a mission, so and they fought the good fight all the way up to the Colorado Supreme Court, and they prevailed. But if it had to go that high, means they didn't prevail all the way because they had to appeal on up. Now, next question. Let's leave the jury nullification aside for now. Are juries competent? What does this mean? Well, if we think about competence, then ultimately we might define it simply as, are juries good, or jurors good processors of the evidence and able to render a fair, impartial, accurate verdict? Okay. Well, let's look at a couple ways in the laboratory that have been demonstrated results that might reflect poorly on juror competence. For example, Pazinski developed this study, the opening statement study. Opening statements are not considered evidence, right? And they shouldn't be processed as such. Opening statements are simply a way to say, hey, I'm the district attorney and I'm going to demonstrate this person's guilty and you're going to find him guilty and we're going to do justice. And the defense attorney's opening statement is going to be, hey, there is not sufficient evidence to convict my client is innocent, and we're going to go through this process and I'm confident that you'll find them innocent, right? Or not guilty is the correct term. So, the power of opening statements. So Pazinski and Reitzman, and again, Reitzman, for whom our textbook is named, right? What they manipulated was, the independent variable is opening statements, either brief or extensive. So brief statements, jurors started with benefit of the doubt, which is the way it's supposed to go, innocent until proven guilty. But extensive statements, we find that jurors then began the trial by assuming guilt, the opposite of the intent, constitutionally derived for our legal system. So follow-up, either defense or prosecution gave opening statement first. When defense went first, they were more likely to find the defendant not guilty. So all else being equal, altering the mechanics of the trial process, either by manipulating opening statement length or allowing the defense to go first, which they don't, the prosecution goes first, we see a change in endorsement of guilty versus not guilty. That is perhaps concerning because, remember, opening statements aren't evidence, but the manipulation of opening statements is affecting the ultimate decision of guilt or not guilty. What do you think's going on? Well, why are they so powerful? Schemas. And now we look at, and all of us have had probably Psych 1100, correct? And some of us maybe have had developmental psychology, and we discuss schemas. That is the way we organize our knowledge. And schemas are something that are present through all aspects of life. But note that we have a courtroom schema, and as soon as we walk in, we want to figure out what the hell's going on. Well, I'm in court. I'm a juror. I've never done this before. I wonder what I'm supposed to do. And then all the TV shows that we've seen about, courts and jurors, etc., provide us some information about maybe what we're supposed to do. That's kind of our best guess because we're completely inexperienced. We're newbies at this. But we begin to develop schemas, right? We begin to classify information on the base of these frameworks, right? They guide people when in a new situation and processing the information that's being presented to them, right? And if there's ambiguous information that's unclear, then we use the schemas to help us get to the bottom of it to understand what it's really about. Now, this is a dastardly study, if you will. This is the false opening statement study, again by Pazinski and his crew, right? The defense in this case promised in the opening statement that an alibi would be presented, or the other condition to which participants were randomly assigned, right? Or said nothing about it. The deal is, the court case unfolds, kind of like a mock trial, right? And no alibi was ever presented. So, subjects who heard the false statement were more likely to find the defendant not guilty. So isn't that strange? At the beginning I say, hey, I'm going to present you with an alibi, and notice this is where the schemas work. Okay, so there's going to be an alibi presented, and then people at the end of the trial then just assume that an alibi had been presented, or somehow process information with that piece of information that an alibi existed. So they process the information differently to allow them to acquit in greater numbers rather than to find the defendant guilty. Wow. So these are basic human phenomenon, right? What's interesting and what's important and what's consequential is this is playing out in a situation that determines people's future and can determine, the most drastic of futures: life imprisonment without parole, the death penalty, what have you, or more minor consequences, maybe just a year or two, but that could be very severe in prison, right? So this juror bias, can it be corrected? The stories that we bring, and either this is bias that we've generated in our life, or bias, in fact, that is part of the process and is, occurring on the fly. I want to talk about a study I did. It was part of my master's thesis. My master's thesis was 4 studies that centered around areas of decision-making within a legal context. In this case, what we did, I produced a story of a fictional attempted date rape, and it was topical at the time. There had been a couple accusations of date rape at Ohio State that gained a lot of publicity during this time, and it was on everyone's mind. So it seemed like an ideal time to capitalize on kind of the zeitgeist on campus, the suspicions, the concerns, the general tension that was created by this. Now, I'll warn you, in our lab we often had big studies. That is, we manipulated several variables at one time. In this case, believe it or not, we manipulated 3 variables, and then we measured participant gender as a 4th variable. That's an individual difference variable. Obviously not something we manipulate. We don't assign people to conditions of male or female. They walk into the lab already having that condition assigned to them from something else, right? But so one thing that we typically manipulated was the severity of the injury, right? And this one is where the study runs into problems and can be considered insensitive. I will say that right up front. Were there possible excuses for the attempted date rape? Okay. So let's talk first of all then about the study. And simply, people read a crime scenario, a date rape scenario, and in the scenario, 2 Ohio State students, a young man, young woman, had been out on their 3rd date, and the young man walks the young woman back to her apartment. Now they get to the apartment door down on the ground floor, right? And at this point, the story begins to have 2 different versions. In one version, what we have is the man making advances. In the other, we have the woman being friendly. So, get to the front door, and in one version, right, the woman says, "Would you like to come upstairs for a drink?" Or, if you're in the other story condition, the man says, "Hey, is it all right if I come up for a little while?" Okay. Now they go upstairs, and what do we see? Well, in one story, the woman goes, "Here, would you like a drink?" Right? And offers a drink. In the other version, it's, "Would you like a cup of coffee?" And then the woman says, "Excuse me," once she's served the beverage, "I'm going to change into something more comfortable." Well, in the one version, she comes out in kind of a negligee type of thing. In the other version, she comes out in her sweatshirt and sweatpants. Okay. In one version, the man lights some candles, and the woman says, "We don't need those," blows them out. In the other condition, the woman says, "Oh, aren't those romantic?" Right? And then a little heavy petting, right? I don't know if you're familiar with that term. A little heavy petting, kissing, hugging, etc. goes on, if I needed to define it. And at some point, it gets a little too heated in the one condition. The woman says, "No, I don't want to do that." In the other condition, the woman says the same thing. "No, I don't want to do that." Okay. Well, the man persists in either condition. Right. Now notice, in the one story, we have components of the story where the defense might argue, the defense in favor of the man, right, committing the alleged date rape, says, well, she did, invite him up. She did kind of come dressed in something sexy. She offered him a drink, right, and talked about romance. So his defense could be built on the potential argument that she led him on, right, and thus excuses the attack, which it never excuses the attack, and I'm not going there, right? So let's get real clear about that. But in the other, it's the man making the advance and the woman just kind of complying every step of the way. Well, as they're struggling on the couch, wrestling around, her trying to escape, and, she falls off the couch. They both fall off the couch. She hits her head on the coffee table. It's a marble coffee table. Now, that's the second independent variable then, is did she just hit her head with no real damage, or and some that she got knocked out by hitting her head and might suffer permanent brain damage as a result of it. So what we have now is the excuse possible? Yes. Or is it impossible? No. What was the severity of the injury? Because we know people will become more prosecutorial. They'll be more likely to convict when the severity of the injury is high rather than low. And notice the severity of the injury is not part of that. Now, so that's the setup. We got a 2x2 design. We know that we have male and female participants, and I'm not big on gender effects, but I knew going into this study that men and women are probably going to look at the story differently. And then what we asked men and women to do in this, our participants to do in this case is, hey, we want you to view this story through the lens of, pretend you're a prosecutor, or view this story through the lens of, you're the defender. Or the third condition was, hey, view it as if you're an impartial judge. And then finally the control condition, we gave no mindset instruction whatsoever. So I know it's a relatively complex setup. This is typical for the way we ran because we want to deal with multiple variables. And I'll tell you something else. If you're interested in doing research, think about it. One of the schools that I applied to when I went to graduate school, wanted to go to graduate school, and I was not accepted, is I applied to Harvard. I was not accepted, right? I was accepted to Ohio State. And look how this works out. This study took 400 participants. A little more than 400 participants because the number of conditions, you need 20 per condition, and you've got 4 times 4, 16, right? You got 16 different conditions here. 20 people per condition, right, is kind of the gold standard. You need like 400 people in this study to make sense of it to achieve statistical significance. At Harvard, interestingly, people who do social psychology at Harvard, they might get 80 participants a semester. So they would have to wait forever to do a study like this, so they have to purchase participants, they have to pay for them. At Ohio State, I can run this study in a single quarter, and I did run. This is in the quarter system, ran it in a single quarter because we have that many participants. If you're ever considering, if you want to be a serious researcher and looking at, boy, I would like to have a lot of participants and run a lot of studies, go to a big state-level school. Ohio State, University of Michigan, UCLA, go to a big school, lots of participants, right? Okay. Harvard might carry the prestige, but it's much harder to get research done. Kind of ironic, isn't it? Let's look at the results now. So, should John pay? And John was the character in the story. Not at all, definitely. And we have a 1 to 7 point scale, which was typical for our work. And what we see is, in the high extenuating circumstances, that is when an excuse was possible, right, that the defense might make a case that the defendant was being led on. What we see is the males who are in the defender role, so the men, male participants, who are told to think like defenders, man, should John pay? No way. Man, they grabbed on to the potential for excuse and they ran with it. Now, notice, if they're a prosecutor, if they've been asked to think like a prosecutor, which is the white bar, we see that, in fact, they could function in that regard to a certain extent. The control condition, right, looks an awful lot like the scientist condition, the judge condition, if you will. We call it both, intuitive scientist. Now, what do we see with the females? And this is the striking difference. When you look at a graph like this, we always ask, where's the action? Where's the big difference? Well, you notice it's in the defender condition. Females who are asked to process this as a defender were unable to do so. Should John pay? Hell yeah. Pay through the nose. In fact, pay as much or more than any of your experimental conditions. There's no difference between the judge condition and the defender condition, and statistical significance difference between control and defender. But note that when we asked women participants to view this through the lens of defender, they were unable to. So I'm making a case that gender, in fact, created a bias where they were not able to process it. Nor should they necessarily need to. I'm not casting judgment upon this. I'm just looking at the frickin' mechanisms. Social psychologists can be kind of angering to a lot of people because we tend to step away from value judgments, etc., and just try to report on the data. Now, if we look at in this one, we see high extenuating circumstances, suitability of prison time, and we have multiple dependent variables. We never hang our hat on a single dependent variable. What we see is the exact same relationship. The men, hey, he doesn't need prison, man. He had excuses. The women are, I don't give a shit. The excuses don't matter, and suitability of prison is high, right? Questions about that? And this is the type of research we did. Can jurors debias? Yeah, sure. Is it likely? It depends. It depends on the situation. Let us then carry on and determine some liability in civil cases. Liability shouldn't be influenced by outcome severity, how severe the damage or injury is. So John's guilt should not be predicated on Sue's injuries in the date rape case. Either he did it or not, the injuries are separate. The injuries are another consideration that comes after did he do it or not, right? And then how should we respond? That is based on the severity. So liability shouldn't be influenced by outcomes of severity, how severe the damage or the injury is. The law says people can separate judgments of liability from judgment of damages. And this is typically what happens. Is the person responsible? Okay, yes or no. And then, how severe is the injury and what should the compensation be? But the strange thing is, the more severe the injury, the more people feel they need to find somebody guilty. And the person sitting in the defendant chair is the natural choice to find guilty, right? So experimental research demonstrates outcome severity determines perception of responsibility and also can cause people to deny alibis when the crime is severe enough. Okay? So based on this, there's a system of what's called bifurcated trials, or I'm going to show you an example of trifurcated, to separate judgments of responsibility from judgments of liability. COAM is a great example here. So I'm on the Committee on Academic Misconduct. And what we do is, if there's a case of misconduct, it's reported to COAM, it goes to the channels, and if the student wants a hearing, rather than an administrative decision, but they want a hearing, then we call the panel, and we hear the allegations from the instructor, and then the student responds, right? And then, after the student responds, the student may ask questions of the instructor, and we're all listening to this, and then at that point, then the panel can ask questions of both the instructor and the student. One thing I found on COAM is typically the panel is an undergraduate student, a graduate student, and 3 faculty, or lecturers, if you will, like me. An aside, I was one of the first lecturers to be on COAM, so that's kind of cool that they're opening the door and treating lecturers like human beings within the university. We're pretty hard on instructors that bring the cases. I mean, if you don't provide good evidence as an instructor, if your case is haphazard or kind of sloppy or insufficient, or you're just trying to catch students for the hell of it, on minor offenses, expect your time as a faculty member testifying in front of the panel to be pretty harsh, because we can be pretty harsh, right? So, to our own, so to speak. Now, COAM employs a trifurcated decision. So once the instructor has set up the case, the student has responded, the student has been able to ask questions of the instructor, and then the panel gets to ask questions of both, right? After we're done with that, we say, okay, you guys, you can go home and we'll notify you of our decision. We adjourn for deliberations. And here's the system we use. The first thing we do is we make a motion to find the student in violation or not in violation. So someone makes that motion, someone else seconds it, and then we discuss. Now, if we find the student to be not in violation, which is always a good day because that's ultimately what we want to do, then we're done. Okay, student's not in violation. Thank you, everyone. Next case, or let's adjourn for the day. But if the panel finds the student in violation, then the student's record at that point in time is read to the panel, but not until we've made the first determination. Okay? And then we decide on a disciplinary sanction. And that could be a formal reprimand all the way up to expulsion with 4 or 5 different steps in between. Like academic probation for 1 term, 1 semester, till graduation, various levels, right? And the deal is, we found the student in violation, okay, or not, but we don't want to hear if the student's got a prior record before that. Because if the student has a prior record, then we might lean towards finding the student in violation again. Right, so it's not until after we've said the student is in violation do we hear of any previous offenses, if there are any. And that then will affect our disciplinary sanction. First offense, in all likelihood, if the student says, hey, I didn't realize what I was doing was wrong, I plagiarized, I didn't understand the rules, and I'm sorry, I didn't mean to do it, but it's obvious I did and I didn't mean to, they're likely going to be given disciplinary sanction of a formal reprimand. That's just a note that goes in their file saying, hey, you did this and you shouldn't do it again. That's the lowest level disciplinary sanction. But if at this point we find that the student has 2 prior violations for academic misconduct, then suspension or perhaps even expulsion in the most extreme cases might be warranted according to the panel. Right? But notice we don't hear the student's prior record until after we found the student in violation or not. And then finally, after the disciplinary sanction, then we have a second sanction that we may or may not apply, which is a grade sanction, if any. And often this accounts, most often is a 0 on the assignment in question. So if someone plagiarized an assignment, then we might say, okay, that's a 0 on that assignment. Now that can be devastating if that assignment was worth 25% of the grade, or if the student was found in violation by cheating on an exam, a final exam, then the grade sanction might be pretty severe as a 0. And we can go up from there too. We can say, hey, 0 on the assignment and lower the course grade by 1 full letter grade. That's up to us. About the most severe we can do is give an E in the course, and we can give 2 types of E's. An E that could be overridden or an E that can't be overridden. Right? But it's an impressive system, and it's a model system. COAM at The Ohio State University is something that other universities look to. It's just an amazingly well thought out and well administered system. So fear not. I mean, sometimes things happen and people are brought up on consequences, but it's about as fair a system as you can imagine. And I'm in my 4th year. I've seen a lot of cases and I've seen a lot go on. One thing I find, though, the most important thing to do is if someone did it, committed a violation, then own it. Say, hey, I messed up. I was under pressure. I don't know what I was thinking. I just couldn't catch up, or I didn't know, and I'm sorry that I did it. And then the penalties are usually very, very slight at that point. People who deny, people who lie, and if you want to try and lie to a panel of 5 people, and they can ask you any question they want, you want to lie, taking big chances there, because people don't own it are generally punished more severely as a result of that. So it's intended to be a learning experience more than anything. So that's not a criminal case, right? It's a case of academic misconduct. We've talked about criminal cases. Now we move on to civil cases. Why is it so hard to separate liability from injuries suffered? That is, fault from the amount of compensation. Well, it could be that we're sorry for the plaintiff, that we feel sorry for the person, and we want to help them. Oh my God, look at this person suffered this severe injury, especially at the hands of some big-ass brutal corporation, and they don't give a shit about people. Let's reward this person, right? So, it may be defensive attributions. The more severe the outcome, the more we want to pin responsibility on someone, because ultimately it will make our world seem more controllable, right? And you can see how this ties to belief in a just world. So super serious crimes, people kind of get blood in their eyes, and if you're in the wrong place at the wrong time and end up in that defendant's chair, that's not a good thing, right? So, now, let's move on. Judges' instructions to the jury. Judges instruct the jury on how to do their deliberations, right? Judges usually read the instructions aloud. Jurors are not allowed to ask questions during the reading, and judges can't paraphrase the instructions too much. So we get into this issue where a lot of times the instructions are heavily written in legalese, if you will, and might be beyond the comprehension of some jurors. So it would be natural to think, because you ask a teacher, hey, what the hell are you talking about? You're talking your psychobabble, this empirical, highfalutin language. Can you explain it in more plain English? And as teachers, that's what we're supposed to do then. We're supposed to explain it until you understand it. But now notice, if a judge paraphrases, every time they paraphrase, it's an opportunity to question the accuracy of the paraphrase and thus the instructions delivered. It opens the door to a greater and greater extent to appeals in the future because of the instructions being paraphrased, if you will. Right? So, what do we know? Well, there's been a lot of research on jury instructions, and this is pretty easy research to do. This is like just typical straight up academic type testing. You give people information and then you test them on their retention and understanding of the content, right? So generally jurors don't understand 40 to 45% of the instructions. So here you are sitting in the defendant's chair, your life is on the line, and what we can demonstrate is jurors understand about half of what they've been told. This is a less than optimal situation, right? Now, reading them at the beginning of the trial might help. Often instructions are given to the jury right before they adjourn to deliberations. But notice, jurors are processing information throughout the trial. A lot of psychologists, decision-making experts say really they should be read up front, right? It helps to set up the appropriate framework, the schemas. It leads to more appropriate decisions, better recall, likely. Leads jurors to hold off on the verdict, their decisions, until the end of the trial, right? And that's hugely important. Jurors better able to integrate case facts with the law. So this leads us to the story model, and the story model is the cognitive process involved in juror decision making. That jurors are active information processors, and they attempt to construct a logical, consistent narrative from the time the opening statements begin. So basically, hey, this is the story. We have two people right? We have a defendant who allegedly committed this murder. We have the prosecution telling us how it happened. Well, what happened? What do I think? And from the very beginning, right, jurors are more likely than not to have a sense of guilty versus not guilty from the beginning of the trial. People aren't really good at just saying, well, I'm just going to sit here and be open to all the information until the trial is over, and then I'll start thinking about it. That's not likely, right? So jurors just don't sit back and absorb evidence. They're always working on it to fit their initial story. This is preferred story. We can soften that, maybe go to initial story. Now, Olson and Falero looked at this, and Saul Falero has done a ton of research in this area. Rape case stories. People with different verdicts remembered the evidence differently. So once we give people a mock trial, and then we separate them by verdict, guilty versus not guilty, and then we test them on the retention of the case facts, we find that their memory for the facts is different depending on their verdict, which tends to indicate that a story was being created and gives preferential memorization to information that's consistent with their verdict, right? And that's very consistent with the idea of how people process information and how human memory works. How do we know that story making happens? Well, Pennington and Hasty use the same evidence, different order, and thus manipulate the ultimate verdicts in that regard. So, we live in an imperfect world. We are imperfect information processors, and one of the places that this has severe consequences among, literally thousands is in the courtroom. So, let's talk a little more about supplying a context, that is developing a narrative. And part of the narrative that we operate under is the time we live in. And one of the most interesting aspects of our research, right, and this study, I'm really proud of this study. Derek and I kind of engineered the study together, and this study is still being cited in current research, which is pretty cool. We can track who's citing our research and when and to what purpose. So that this article is still being cited in current research is kind of a kick for us, right? In this case, what we did was we manipulate perception of the social order. That is, we believe that if people potential jurors believe that crime is out of control, they'll be motivated to clamp down. That is, to right the wrong, to restore a sense of control to society. So if the pervasive societal attitude is, oh my God, this shit's out of control, when we do actually catch someone, we're likely to be harsher on them and need less evidence to convict them because we got to restore order. So, we got to maybe make examples of some people so that we get things back under control. Now, the big question for social psychologists is, okay, so you want to manipulate, right, perception of the social order. How the hell are you going to do that? And I thought, well, one thing is if we believe people are getting away with stuff, then we believe society is out of control, we're going to clamp down. If we believe that society is effectively dealing with wrongdoers, that people aren't getting away with things, they are getting caught and punished, then we can relax a little bit because the system seems to be working. So I said, why don't we just manipulate the arrest rate? That is, we'll have people read a story about a crime, and we'll ask them to assign punishment for the person who committed that crime, right, or allegedly committed that crime. But before they read about the crime, let's give them general information about the crime, which includes the arrest rate. So let's set people up, let's prime people with thinking either this crime is under control, that is, it has a high arrest rate, or this crime is out of control, it has a low arrest rate. So, people are randomly assigned to two arrest rate conditions, 8% versus 92%, and we like to keep it simple, right? There's two ends of the continuum, and notice it equals 100% because we're slick like that, or not. Here's one example crime. We did this with 3 different crimes. Again, you can see how many of us who do research in this area do it in a very similar fashion, kind of an accepted procedure. So the crime type, in this case, carjacking. So this is what a participant would read. Crime type, carjacking. Size and scope of the problem. Less than 8% of the estimated carjackers are ever arrested because of the large number of carjackings and the speed with which the crime is committed. Few carjackers are ever arrested, and even fewer are successfully prosecuted, and because of this, the crime mostly or most often goes unpunished. So this is the out of control condition. Now, you might have been randomly assigned to this condition, or you got randomly assigned to this condition. Right? And notice, it's just a flip of the priming manipulation. Size and scope of the problem, approximately 92% of those committed carjacking are eventually arrested because of the relative public nature of the crime, the large number of witnesses. Most carjackers are arrested, successfully prosecuted, and serve jail time for the crime. Shit's under control. Right? So now, participants read this, and they're told they're going to read about multiple cases, then they're given the actual case. So, example of carjacking and its consequence. While sitting at a stoplight, a carjacker forced open the driver doors of Roger Berger's car. The carjacker shoved a pistol into Roger's face and demanded that Roger get out of the car. Roger slid across the seat and fumbled with the passenger door trying to get out of the car. Just as he got out of the door, the carjacker stomped on the accelerator and took off. As the car sped away, the passenger door slammed shut, and Roger stood in the road watching his car disappear around the corner. So again, priming manipulation about the nature of the crime. Is it in control or under control? Then all participants read this. But now we have a second independent variable that we're going to manipulate, and that is the severity of the outcome, like we did in the date rape case. Right? Two different endings. The low severity ending to the story. Right? Roger was shaken but physically unharmed. He stood in the street for a moment in disbelief that what has just happened had actually happened. As he began to get over the shock, he was glad that at least his car was insured and his losses would be minimal. So all else being equal, it could have been a lot worse. How could it have been worse? Well, let's look at the high severity ending. The stress and the excitement of the theft were too much for Roger. He clutched at the stabbing pain in his chest and collapsed on the pavement. By the time the paramedics arrived, Roger was dead. I know. Our lab had a reputation for killing more people in scenarios than just about any other lab in the country. Now, the reaction to the threat. What do we see? Well, we manipulated the severity, so moderate, Roger watches car drive away, or severe, right? The mean prescribed punishment is how much the carjacker should be punished. And what do we see? When we're under low threat, that is these bars here, and it's moderate, people back off on the punishment. They perform rather leniently. But if they believe that the arrest rate is low, that is, it's out of control, then they come down very hard. Wow. All right. So, something that we didn't know, how we expected this. We hypothesized this. We said that's going to happen. But the second part, when it's severe and out of control, we said, well, what's going to happen when it's severe and perceived to be out of control? Are we going to get like a double whammy? That is, people are going to clamp down doubly hard because the outcome was severe and the crime is perceived to be out of control? And interestingly, no, there was a threshold. So once you activate punitiveness, you activate it, and that's as good as it gets. So notice, out of control, hey, got to get punitive. Severe injury, but in control, got to get punitive. Severe injury and out of control, got to get punitive. As Derek put in the article, he said, we wondered whether it would amount to a single or a double pull of the trigger. And note that the trigger can only be pulled once in this case, as the metaphor. Once severity is activated, it is severe or not, right? So, fascinating study, I thought. Now, we did this, the second crime we did with identity theft and the cleaning out of someone's bank account, etc., manipulated in the same way, and the results were exactly the same. And that's when you know you're solid, because you take two radically different scenarios and you say, hey, here's the deal. Now, The third scenario, though, we could argue didn't work, but it told us a lot. And in the third scenario, the crime was home invasion robbery. And with home invasion robbery, it didn't matter. The bars were all the way up. So at that point, we said, well, that didn't work. But then, Derek and I sat back and said, well, actually it did. I mean, home invasion robbery is about as severe as anything anyone can imagine, right? And it's as scary as anything can imagine. And even if the arrest rate is high for home invasion robbery, it's gonna wig people out. So there's going to be a desire to punish harshly no matter what. So again, context matters, right? And that's why I found research in this area so fascinating, because there's so many variables that can be studied, and so many unique combinations to what we observe. So enough of that. Let's talk some reforms as we close this up. Some reforms do take into account the fact that jurors are active information processors. So think about some potential reforms, and this is homework 9, part 2. Pre-instructions, instruction given at the beginning of the trial. This is something that could be done, and we can demonstrate should have positive consequences in short-circuiting the story model to some extent. We could provide jurors with written copies of the instructions so that they could study them for some period of time. That doesn't seem amazingly problematic. Now, some of these are a little different. Should jurors be allowed to take notes during the trial? Because let's face it, a trial could go on 1 week, 2 weeks, 3 weeks, maybe a month and a half. Might be pretty easy to get confused, right, or misremember certain aspects as you're moving through. Should jurors be allowed to take notes? What about, and this one is probably one of the more challenging of all the reforms possible, should the day end for the trial like at 3 p.m. and then jurors adjourn from 3 to 4 to discuss what happened today in the trial, and do that on a daily basis? Because notice what jurors do is they're not supposed to discuss the case until deliberations. So it's trial, discussion. Should it be trial, discussion? What would the difference be? How would that work? And notice, if you're interested in doing research in this area, oh my God, there's so many research opportunities. There's so many hypotheses to be tested. So, should jurors be allowed to ask questions? Now note, if you look at trials in an inquisitorial system like Great Britain, right, the judge can ask questions, right? Well, should the jury be able to ask questions? If they're unclear about something, should they be able to write a note? Let's say, for example, hey, what about this? And then have the bailiff pass that note to the judge, have the judge read the note, and then decide whether that question should be asked or not during the trial. Think about it. Should you guys be allowed to ask questions about assignments or content? Of course, right? Of course you should be allowed to ask questions. I always ask you, do you have any questions, right? Because if you're not clear, I want to answer your questions. I want to shoot for clarity. Should that happen within a courtroom setting? Should we simplify the language in the instructions? Okay. Now, here's the deal. We can create a lot of studies to test each one of these. But remember the fourth dilemma. That is, people in the legal system do things differently than people in the science system. And there's especially a distrust of psychologists. And well supported, because when you see psychologists arguing that this person is insane, this person is not insane, they should be held responsible. No, they shouldn't be held responsible. They got psychosis, but they're not mentally ill. I mean, people develop real easily in the court system, develop a fundamental mistrust of psychologists as being all over the map and saying just about anything. That psychology is not a science. And yes, it is. It's a soft science, but it's a science, right? So, there's a distrust of science and psychologists' research findings to a huge extent. Now, homework number 9, part 2 then. Please consider the reforms listed on the previous slide. Each team member select one. Then, each team member, for the one they selected, will do all 5 of these questions, right? Describe the reform. Discuss the need to reform. and that could be probably pretty simple. What are 2 pros of your suggested reform? That's why would this be a good idea? And then, you got to flip it around, right? What is 1 con to the reform? And then 5, can we know how the reform was effective, and if we can, how so? That is one thing to do a reform, but remember needs assessment. So is there a need for this reform? The program design is, what does this reform look like? And then the evaluation component is, how do we know that this reform was effective? How did it address the need? And that, I think, is the problem, the most problematic. It's easy to say, yeah, there's a need, and yeah, we'll do this, but how do we, and this is where you're really going to have to put your thinking cap on, enter your imaginarium, if you will, how do we know? What will tell us that this is effective or ineffective, right? And if you want to go from, we're going to test this in the laboratory and talk in terms of the influence on a dependent variable, that's one thing, okay? If you're going to talk more globally, it becomes maybe a little more difficult. If you're going to talk real world, then what are we going to notice is different over time? That might be a more difficult approach. So if you want to take a simpler laboratory approach to answering that question, I'm okay with that. In rereading this a couple times now, I know this last question is pretty tough. But notice what I also did with this question is I said why or why not, right? If not, why not? So you got to cover your base there. Anyway, that's it for this one. I hope you guys have a great day.